From the 4th to the 6th of December 2019, the Appeals Chamber of the International Criminal Court held a hearing to receive oral submissions on the appeals against the 12th of April 2019 Pretrial Chamber 2 decision on the situation of the Islamic Republic of Afghanistan, rejecting unanimously the prosecutor's request to open an investigation for alleged crimes against humanity and war crimes. At the opening of the hearing, and on behalf of the Appeals Chamber, Presiding Judge Piotr Hofmansky provided some detailed background information.
On 12th April 2019, the pretrial chamber rendered the impugned decision finding in the relevant part, I quote, "Having determined that both the jurisdiction and the admissibility requirements are satisfied, it remains for the chamber to determine, in accordance with Article 53(1)(c) of the statute, whether taking into account the gravity of the crime and the interests of victims, there are nonetheless substantial reason to believe that investigation would not serve the interests of justice." End of quote.
Scheduled for 3 days, this appeals hearing was attended by the Office of the Prosecutor, the legal representatives of victims, the cross-border victims representatives, the Office of Public Counsel for Victims, the Islamic Republic of Afghanistan, and representatives of Amicus Curiae. All of them were asked by the Appeals Chamber to present observations on 3 questions. Can victims bring an appeal? Is the impugned decision one that may be considered to be a decision with respect to jurisdiction? And what are the merits of the appeal? In relation to the standing of the victims to bring an appeal, they argued on legal aspects and defended different positions. For the legal representatives of victims, victims should be considered as parties and have the right and even the need to bring an appeal. Among the legal representatives of victims' teams, Mrs. Nancy Hollander described, as an example, the case of a prisoner of Guantanamo that she represents.
And now we know that not one shred of actionable intelligence was learned from the torture and interrogation of any of the prisoners held in the black sites all over the world. Not one piece of actionable intelligence. No one from any country ever stepped in to stop the torture. No country has investigated what happened or sought to prosecute anyone involved in or knowing about the torture. No country stepped in to stop Mr. al-Nashri from being transported to the Guantanamo Bay prison, where Mr. al-Nashri is still held in solitary confinement and has yet to have a trial, now almost 18 years later. Yet the torture, imprisonment, and deprivation of rights continues to this day. He has been charged with numerous crimes. He was first charged in 2008. He faces the death penalty if he is convicted. In many ways, his torture has not ever ended.
The different groups addressed to the Appeals Chamber what they considered to be legal errors from the pretrial chamber. Mr. Fergal Gaynor, a legal representative of victims, said,
"A perfect illustration of this is the Article 15 decision concerning Myanmar of 14th November 2019, where that pretrial chamber strikingly took a very different approach to the Afghanistan pretrial chamber. In their decision, the 2 decision sections on jurisdiction took up about 60% of the pages of the decision itself. It plainly was a decision with respect to jurisdiction. Nobody can reasonably insist that it was not. And if the Myanmar-Bangladesh decision was a decision with respect to jurisdiction, so is every other pretrial chamber decision which authorizes or refuses to authorize the commencement of an investigation.
As for the merits of the appeals, many, including the OTP, the LRV, and different Amicus Curiae, asked the Appeals Chamber to reverse the impugned decision. However, the Islamic Republic of Afghanistan urged the Appeals Chamber not to do so at this stage, taking into consideration that the state is legitimately willing to open an investigation. QC Rodney Dixon, a lawyer for the Islamic Republic of Afghanistan, said,
"The plea of Afghanistan is for the fundamental principle of complementarity to be given full effect. The nation must be given the opportunity to continue its investigations and strengthen them in light of the severe obstacles that are faced on the ground, with the support of the court. And very importantly in that regard, to be, as Afghanistan, reporting back to the court on its progress each step of the way so that the position can be constantly assessed. Afghanistan wishes to embark on this course hand in hand with the court. It is not in any sense a competition. Instead of authorizing an investigation that could be opened for many years, realistically, without any major movements, and I say this recalling that the preliminary examination has itself lasted 11 years, rather focus all the attention and resources on the national initiatives that are already underway, which would benefit from the court's support, of course always with the backstop of being able to refer the matter back to the ICC if that were necessary. We submitted would send a very powerful message to the country that the national justice system was legitimate.
On behalf of the OTP, the director of the prosecution division, Fabrizio Guariglia, repeated in his final submissions the prosecutor's resolution to open an investigation.
Based on her careful and independent analysis during the preliminary examination, the prosecutor was and remains resolved to open an investigation of these matters and to make her best effort to deliver justice to the victims and hold perpetrators to account, as her mandate requires. We know that this will be difficult and the road ahead may still be very long. But we will approach this task with all the resolution, independence, and diligence that we can muster, without fear or favor, as we must. It is in this context that we have been particularly concerned by the reasoning in the pretrial chamber's decision. The difficulties arising from the decision have been thoroughly addressed in the various written submissions and in the oral arguments that your honors heard this week, and we do not propose to revisit them again. On the basis of the arguments that we and other colleagues during the last 3 days had made before this chamber, we renew our request to your honors to reverse the decision in its entirety and authorize the commencement of the investigation, or, alternatively, to direct the pretrial chamber to do so without any further delay.
On the 5th of December 2019, the Appeals Chamber rendered an interlocutory oral decision on the first issue addressed during the hearing, i.e., whether victims have standing to bring an appeal against the pretrial chamber's decision on Afghanistan. The majority of the Appeals Chamber, Judge Luz del Carmen Ibanez Carranza dissenting, held that the appeals brought by the legal representatives of victims are inadmissible. This, due to the fact that victims do not qualify as parties to appeal this decision. However, the legal representatives of victims can still participate in the appeal brought by the Office of the Prosecutor and can still make representations. At the end of the hearing, Presiding Judge Piotr Hofmansky announced that the Appeals Chamber's full decision will be given in due course.